Good evening and welcome to this event. I'm Stephen Warbler, as I'm sure most people know. It's on the stands in front of me. So tonight, with the aid of a distinguished panel on my left, and as organised by the Transparency Project, we're going to debate whether, in the context of the family court, privacy should trump accountability, or to put it another way, to what extent should the work of the family court be conducted and scrutinised in public? We're grateful to the President for permitting us to hold this event. There are very strongly held views on this subject, and the very large number of people here reflects the public interest in the issue. Transparency is not about the creation of salacious headlines in tabloid newspapers about the private lives of individuals, nor is it about creating an outlet for the compulsions of the academic classes to create a name for themselves on social media. Transparency is about allowing the public a right to have a say in the manner of operation of a public institution, and also the right to have an understanding of how to access that institution. If people don't know how to access justice, how can they find it? So this is an important debate, and there is much to learn. We all hope that you will feel able to join in with the debate. It's important because perhaps on the one hand, what happens if a public institution operates behind closed doors? Or what does happen? On the other hand, how would you feel if your most private issues were displayed on the billboard outside the local corner shop? Do you trust the press? Think about the phone hacking that went on. For this debate to be successful, I do have to ask you to observe the ground rules, and you've got copies of those with you. There are some particularly important ones, and they include this: please don't try to discuss the facts of any case in which you might be directly involved, or particular family cases, save where you are certain that you will not be breaking the law, or orders that have been made in that particular case. The responsibility for anything that is said must rest entirely with the speaker. Please, can I ask you to keep your questions or points short, in order to make sure that as many people as possible have their say. I will limit any questions or points from the floor to 1 minute at most. Please try to keep them shorter than that. Questions, please, should be addressed to me, and I will then assign them to the panel members or invite responses from the audience. Please wait for a roving microphone before you do speak, and it's up to you whether you give your name or not. Timings are going to be as follows. After I've finished for 10 minutes, the panelists will introduce themselves and give some preliminary thoughts on the topic under debate. Then from 6:20 to 7:20, the debate will be conducted, and we will invite comments and points from the floor, and the panel will engage in the debate too. From 7:20 to 7:30, Lucy Reed will give an introduction to the Transparency Project's guidance note for families and professionals about the publication of family court judgments. And then from 7:30 to 9 o'clock, you're invited to join us for drinks and a reception, with thanks to Simpson Miller for sponsoring the event, and also to the Legal Education Foundation. I wonder whether we could begin with just a show of hands, if you're prepared to do this. Who thinks that the family court should be more open? About an equal split, is that fair? Pretty much an equal split. If I remember, let's do the same thing at the end of the evening to see if views have changed. Well, now, if I may, I'll hand over to the panelists, beginning with Sophie on my left, to introduce themselves and give some preliminary thoughts on the topic.
Hi, I'm Sophie Ayres. I'm a social worker, and I worked in statutory services for 9 years before making the decision in February to become an independent social worker. I suppose my thoughts about privacy in the family court have evolved and changed over the course of my career. And I think at the start of my career, I was very much at a viewpoint where I thought that all details should be protected and that was in the best interest of children. However, I think the longer I've practiced, I've come to see that actually that can create quite a defensive culture and doesn't enable local authorities or social workers or other organisations to learn from what's occurred. I am quite reticent at times about how impartial the press can be, and I think there's some really good examples of very positive reporting, but I also think there's some very poor examples of very irresponsible reporting that can put children at risk and also professionals at risk as well. And I think where I'm at the moment is I do believe there should be increased transparency in terms of what goes on in the family court. And I do think local authorities need to assess how they engage with the press and perhaps adopt a less defensive approach. However, within that, I feel it's incredibly important that we are always mindful of children's rights, children's ability to have their private lives protected, and to ensure that it's not catastrophic for them to learn about their personal, private, intimate details, and for the whole community to know about that.
Hello, I'm Lucy Reid. I'm not on your list of speakers, but I'm the chair of the Transparency Project, and I'm just stepping into the breach today because you'll have noticed that there are two people missing from our panel today. Hannah Markham QC, unfortunately, has been caught up at court today in Nottingham and hasn't been able to make it, but she has sent me a message of what she would have been saying now had she made it here on the train. So I'm very grateful to Hannah for putting this together on her iPhone whilst dealing with a crisis at court in Nottingham. What she says is, my view is that it's helpful and necessary for the public to understand and have access to reported cases, in particular those where authorities or professionals or experts err, either in their day-to-day conduct or within the scope of the proceedings. However, the question of publication must not be at the cost of losing the privacy of the children and, on occasions, the adults. The driving force of Children Act cases is protection of the subject children, and this ought not to be lost. In cases where families have been failed, it's vital that lessons are learnt, and if publication and transparency assists this, then this can only be for the greater good. I don't, however, accept that in many cases where there may be some criticism of professionals, that the public airing of those minor misdemeanours assists those working in the family arena. There must at all times be a very careful balance between ensuring that matters are not covered up or withheld from public knowledge, or sharing with protecting the family life of those involved, and at times the professional integrity of those working in this area. What is dangerous is the misquoting or inaccurate reporting of judgments with headline-grabbing slants. Greater transparency can only lead to better working practices and better trust in the system, with as much information as can properly be shared being shared. So that's what Hannah wanted to say. Andrew Pack also, unfortunately, is unable to be here tonight, but what he says to me via a direct message on Twitter is, I would have said that since the guidance came out, I've read all the judgments and seen only 3 supervision order cases, i.e. the ones where things have gone right. And he's talking there about the 2014 guidance on the publication of judgments, which was intended to lead to more published judgments. What he says is, good news, writes in white ink so far as the press is concerned, but this selection bias of publishing only the parts of the system where judges are castigating someone, usually professionals, creates a skewed perception of if the examples of good practice are silent or missing. So that's what those two would have said. You don't need to hear any more from me. I'm going to pass this on.
Hello, my name's Callum May. I'm a journalist. I happen to work for BBC News. Boring disclaimer, I'm presenting my own experiences and opinions here and not those of my employer. The question that is being asked here is, should privacy trump accountability? I think it's necessary to have both, and I think we do have both. Journalists are, whatever anyone might think, not trying to get around such privacy restrictions that exist. I find myself trying to work inside them a lot of the time. Yes, there may well be bad reporting, it does exist, but there are bad examples of work in any profession that you could find.
Good evening. My name is Jonathan Baker, Mr. Justice Baker. I'm the judge of the Family Division, and I'm the Family Division Liaison Judge for the Western Circuit, so that means my responsibility stretches across the southwest of England, including Bristol. I'm very pleased to be here today to take part in this debate. It's an extremely important conversation, and I'm here to say something, but principally to listen and to learn from what you have to say and what you think about this issue. For decades, the family courts have operated in private, and professionals like me and like most professionals in this room working in the family courts have grown up with that assumption that what we did will be done in private. And it's been very challenging to all of us to get to grips with a different way of thinking. But there has been a different way of thinking because of a growing realization that there was a serious lack of connection, lack of confidence, and lack of understanding about the family court. And that's led to a whole raft of myths and misinformation about how the courts work and the decisions we take. So we've tried over the last few years, under the leadership of Sir James Mumby, the President of the Family Division, for whom this is a burning issue, to find ways of opening up the family court. It is extraordinarily difficult to do that because the issues with which we are concerned are intensely private. In particular, and most obviously, issues about small, vulnerable children, many of whom have been subjected, allegedly, to abuse and neglect. In publishing information about what is alleged to have happened to them is a very serious invasion of their privacy. And this in a jurisdiction where it is the child's welfare that is our paramount consideration. So it is a very difficult balance to strike, and we are still trying to find ways, struggling to find ways in which we can operate in a more open environment. As a first step, the President introduced a much wider, he relaxed the rules about the publication of judgments. So there have been, as you've already heard, a greater number of judgments published from family cases, usually anonymously, or in a way which is attempted to be anonymous, to try to protect the privacy of the children and the families concerned, whilst demonstrating the issues and, it is hoped, the way in which courts reach their decisions. But that is not as easy as it sounds. Two examples of why that's the case. First, as you've already heard, in deciding which cases should be published, we don't publish every judgment. It would be impossible. Well, it would be very difficult to publish every judgment. But publishing judgments anonymously involves an enormous amount of extra work and time. And we simply don't have those resources. Secondly, there is, as you've already heard, a danger that if you select the judgments to publish, there is a danger of some sort of unconscious bias as to what you publish. And as one of the contributors has already mentioned, talking through Lucy, there's definitely been a tendency to publish judgments where things have gone wrong and professionals have been castigated or criticized. And that's by and large not the experience of the family court. By and large, most professionals do their job extremely well, and there is a very high standard. So how do we get the balance right? There are a number of issues about that. And the third issue is the question of anonymization. Can you really anonymize a judgment? And even if you do put a judgment on the internet, you may think it's anonymous, but is it really anonymous? Is it anonymous to the victims or the young people themselves? How will it be for a young person, years later when they're grown up, to find on the internet an apparently anonymized judgment referring to their experiences? It will be anonymous in some respects, but not to them. So there's just a few of the many issues which arise in this area, and I hope that we can discuss those, and I'm here to learn, as I've said, and I look forward to hearing what you've got to say.
Good evening. I'm Gretchen Precy, and I'm an independent social worker, but I'm also chair of an organization called Nagalro, which, if you're not familiar with it, Nagalro was founded in the mid-90s, and it was an organization that mainly dealt with the professional association for guardians ad litem and reporting officers as it was then in the pre-CAFCAS days. We still exist, but most of our members now are independent social workers. We still have social workers who work for CAFCAS and some who are associates of CAFCAS, not employed by them, but who do independent reports on their behalf. And for myself, I'm an independent social worker. I've been working independently for about 15 years. But prior to that, I was a social worker in the local authority for about 25 years. And my most recent period of employment as a proper social worker was when I was at a child protection unit that specialized in working with children who'd been sexually abused. And I think what I'm really primarily concerned about is trying to avoid secondary victimization of children through the court process, of them either advertently or inadvertently being named. And the guidance speaks a lot about the jigsaw factor, that it maybe not one piece of information may be compromising for the child, but the pieces of information put together can sometimes make the child feel very exposed. And these children have had horrifying experiences already, and for them to feel very exposed by the way that these things are reported in court, I think we need to be very wary of that. I certainly understand the need for increased transparency, but I think it would be tragic if children were the victims. So that's a lot of my position tonight.
Hello, my name's Louise Tickle. I'm a freelance journalist and I mainly write for The Guardian. I do a lot of reporting on family law and family courts. I would like to echo what Callum said, which is that responsible journalists are not interested in opening up their reporting so that it identifies children. That's not what we do. It's not what our editors allow us to do, and it's not what our lawyers would allow us to do. I think people might be surprised at just how seriously it's taken and just how much time is spent on making sure that that doesn't happen. But I don't report news. I report on processes, which means that I write features about how things go wrong and how potentially people might think they could go right. And what I would say is that from my experience over the last 3 years, it is still very hard indeed to hold the state to account when it comes to family law. It is, and I've said this before, the very hardest reporting I've ever done, because I try to do things in a lot of detail and with a lot of nuance, giving everybody the chance to speak, those people who want to, which is not always the state. So there are about 70,000 children in care at the moment. There are more adopted. There are about 180,000 children living in kinship care, some of whom will be on care orders, some of whom will be on special guardianship orders. There are all their families and all their adoptive families and their foster carers. Now, that's an awful lot of people to be involved in a system where there is very little scrutiny or accountability and where the state has enormous power over their lives. The current situation, I think, is pretty dangerous in a democracy, and not just because it's incredibly onerous to secure permission to report details of what goes on in family courts, even if you promise anonymity, but because it stifles journalists before we can even start. And I'll give you an example from the last week. This is from the editor's mouth. This is Gail Champion, who edits BBC Radio 4's File on 4 documentary strand. And I had pitched her a really extensive idea about doing a piece on why so many children are in care. And the answer I got back from her was, and she's agreed that I can share this with you, is I just think it's unbelievably difficult to get around the reporting restrictions of the family court in order to illustrate cases well enough for radio. We did a programme a few months ago about adoption, and it was terribly hard to bring to air. So she's not just speaking from fear, she's speaking from experience. I'd also suggested doing a different piece on kinship care, to which she said this. Again, the same problem arises with cases and what can be said about them. So we can't even start to look at something which is of enormous policy importance, which the president of the Family Division has written extensively about, the rise in the number of children in care. I can't even start to look at that, even though she would like to. Finally, I suppose what I'd like to say is I don't know any state function that operates better without scrutiny. You can think of virtually anything, and there are levels of accountability there, and by that I mean public accountability. I don't know anything else apart from issues of national security where this level of obstruction is created for journalists, responsible journalists, to try and show people what's being done in their name. And as a profession, I'm really sorry to say this, but I found that social workers are unused to being publicly accountable, and many senior social workers I found to be constitutionally opposed to it. And I'm not convinced that this is always about the privacy of the family involved. I think it's about corporate reputation too, because when a journalist turns up, believe me, so does the head of press. Finally, I'd like to say, after giving a talk to some family law judges last month, which was an amazing experience, I can tell you, at the Judicial College, I actually found a lot of judicial sympathy for journalists wanting to report on these cases. Don't be so worried, they said, after I'd agonised for an hour about all the difficulties I had. Fine for them to say, I thought. Anyway, we plug on. But I did find that they said that they would try to look positively on applications to report care proceedings, as long as care could be taken not to identify those people involved.
I'm really sorry, I forgot at the beginning, because I'm a hopeless organiser, to give you the boring talk about fire exits. So, doing my best impression of an air hostess, exits are over there and out to the left, and there's one over there, or you can go out through the front. And the toilets, if you haven't already found them and need them in the course of the evening, are back out and around to the right. So that's the boring announcement done. Sorry.
Right, thank you. Are there any points, any questions that anyone would like to raise straight away from the floor, please? Anyone who has a question that they would like to raise? No, thank you, yes. Do you want to wait for the microphone?
The reason I'm asking this question today is because everybody seems to have discussed about children and protecting them. I think we're all here definitely to protect children today. My concern is, because the courts are closed and they are secret courts, that how the effect is going to have on children when they grow up in the next 10 to 15 years, because they're not being supported and they're not being considered. I know of children that actually want to speak to judges themselves and would like to be able to voice their feelings directly to a judge or a person of authority. I think that's really important for children to be able to do that.
Okay, thanks. Would anyone like to pick up on that point from the panel, please?
I agree.
Yeah. Louise, do you think we...
The longer answer is there is a reform programme for expanding the opportunities for children to talk to judges and for improving the way children's voices are heard in court. In fact, the system believes that it has a very good way of ensuring that children's wishes and feelings are taken into account. Children in care proceedings, for example, are represented by a guardian, so they have their own voice and their own lawyer, paid for by the taxpayer, non-means tested. So traditionally that's been thought to be a very good system. But you're right, there is a growing perception that, particularly with the growing awareness of children's rights, that we need to do better and do more about that. There is a process in place to try and improve that. It's proceeding, I regret to say, much more slowly than the President and I would like. And I've just become acting chair of the Rules Committee, and I'm trying to do what I can to speed that process up. We've just introduced a new way of working, a practice direction for vulnerable witnesses and vulnerable parties, as you may know. We hope to introduce a new practice direction for children. That involves resources and difficult decisions, and of course, when we don't hold the purse strings, it depends to some extent on government. But certainly we are hoping to find ways in which we can hear more clearly what children want to say to us, directly, rather than through the in my view, excellent guardians, by and large, who represent them in court at the moment.
Yes, thank you. Louise, do you have any views on that, about whether we involve children sufficiently in proceedings, and also as to the benefit that might be derived from involving them all?
I'm not going to quite address it in that way, because I'm going to address it as a journalist. I am constantly asked, where is the voice of the child? There are real difficulties with that. I had a commission last year from the Guardian's Weekend magazine to do a really big piece looking at the experience of children in care. It was a piece I proposed and I passionately wanted to do it. The issues that you face doing that, it's not just about getting permission from local authorities, which is difficult enough for very good reasons. The issue you face is that in order to make this an interesting story for a reader, in fact, in order for a reader to understand the reality of that child's life, you would have to give a lot of identifying detail. And that puts you in a great deal of difficulty because it's very hard to anonymise when you have got that much detail. So you end up in a double bind. You end up with a local authority understandably extremely nervous, and I ended up in conversations with two, and we just couldn't get it away, as well as a big foster care agency who tried very hard to help. Because wouldn't it be amazing to hear the different experiences of children in different kinds of foster care? I would have loved to do that piece. But there are good reasons, I think, why that didn't happen, and I couldn't find a way around it.
Okay. Are there any views from the members of the audience on that point? Please, would anyone like to express an opinion about it?
Can I make one more? I promise I'm not going to do all the talking, Stephen.
What?
Can I just make one further point? One of the many striking things has happened in the last few years as the President has tried to introduce a gradual expansion of transparency in the family court, has been the reaction of young people themselves. Because as Louise and others will know, there is a very strong and vocal young people's group on Family Justice Board who have expressed strong opposition to the very limited reforms that have already happened. So when young people themselves are given the opportunity to say whether or not they want cases reported, even anonymously, very many of them say in an extraordinary loud and clear way that teenagers can, no thanks, we don't want our private lives published, thank you very much. So we have that. I'm not saying that's a universally held view amongst young people, but it's certainly a strong voice. So if you listen to the voice of the child, it seems to me you've got to take seriously what they say. It's one of the many difficulties we face.
Yes, sir. There's a mic coming your way.
Whilst that microphone's coming, I just wanted to say from my experience working in courts, doing quite a lot of care proceedings, children are now routinely asked whether or not they want to speak to the judge or write a letter to the judge. And in almost every case I've had over the last 2 years where I've heard that a child has said, can I meet the judge? The judge has said yes, and they've met the judge, and they've said what they wanted to say. So I just wanted to put that out there in case people think that it's still a rarity. It doesn't happen in every case, and it doesn't happen so often in a private law case. But where there's a guardian involved, children are asked about that if they're old enough to understand the question.
Michael Lefkovich from the charity Families Need Fathers. I've got some real reservations about some of what's been said here about the way that we listen to the voice of the child and giving them that voice. I can completely understand why some children want to have the opportunity to meet with the judge, talk to them, because they know decisions are being made about them. At the same time, a child, for example, who's been in an abusive family relationship will quite often say that they want to stay with the abusive parent. A child who has been manipulated by a parent and alienated in some way will say very forcefully how they hate the parent who they, up until a few months earlier, loved very much. And then they will protest that they're not being listened to if they're not listened to. So it is quite a difficult thing to get right if you're going to involve a child. And in an ironic kind of way, whilst we discourage parents from putting the child in the middle of the conflict by making them choose between parents, we think that's a bad thing generally, we then provide them with lots of different figures of authority, from CAFCAS officers to judges, where we ask them to do exactly that. Choose what would you like to happen? Would you like to be with mummy or daddy?
Okay.
Or how would you see the future?
Thank you. Could I ask Callum, what do you think would be is the benefit, if any, of a child seeing a judge in a set of proceedings when a guardian or a member of CAFCAS has already spoken to the child about what the child might want or feel? So what is the actual benefit of the child seeing the judge?
It's not something that's occurred in any of the family cases that I've covered, and that level of detail in the kind of reporting that I do, which is not the kind of in-depth work that Louise does. It's news journalism. Actually, wouldn't get reported.
Okay.
So a judge's private discussions or even representations about a child's personal contact with a judge is unlikely, I think, to be reported.
So, Sophie, what would you see the purpose as being of a child seeing a judge when there's already been a professional discussion with the child as to what the child might wish or feel?
I think I see children who are going through care proceedings feeling very much that they don't have any control over the process, and a lot of decisions are being made about them and being told what's going to happen. And quite often there's a view that whilst social workers or guardians are listening to what they're saying, they can't always be clear that it's directly going back to the judge. And I think it gives them that certainty that their views are truly represented. And I have to say, I had a really powerful instance with somebody I worked with, and I agree we do need to be really cautious about how that work is undertaken, because there are all sorts of emotional pitfalls within that. But I do think there can be a lot of preparation done with the child in terms of what that represents, what it's going to look like, but also being really clear and honest that you may express a certain view, but unfortunately that view may not change the decision that's made about your future. And I think for social workers or any professionals, guardians, have to be very clear, and that should be the starting point with any child, but I certainly have seen it to be extremely powerful.
Okay, thank you very much.
Can I just say one thing, because I was initially listening to this question and the responses thinking, what has this got to do with accountability? But actually, I quite often encourage judges to either write a child-friendly order or to write a letter to the child explaining what the decision was, and particularly if they haven't done what the child has said they want to happen, explaining why they've done something else. And Mr. Justice Peter Jackson's letter to the 14-year-old is a really powerful example of that. And it seems to me that's about a culture of judges owning their decisions and being accountable to the children that they're making decisions for.
Okay, thank you. Well, for myself, I know a lot of teachers, and they can't understand what the problem is. They say, well, we listen to children all the time, and actually, if there's an issue that arises in relation to a child, we don't have any problem in recognising the importance of listening, and that's the purpose of seeing a child. I think we've had some written questions, and maybe we'll turn on to one of those, please.
Okay, so I've got one question from who says, do you think the public have the right to know what family court outcomes are for anonymised children whose history and circumstances are already public knowledge and reported on through published serious case reviews? So what she's asking is about cases where there's been a serious case review because there's been a death or serious harm to a child, and there's connected family court proceedings. Should we know about those family court proceedings so we can piece the jigsaw together and understand what's gone wrong and maybe what could change?
Gretchen, I don't know if do you have any views on that?
Well, as somebody who's been an overview report writer for serious case reviews or practice reviews, as we're calling them now, this is another subset of questions about how anonymous we should be making these detailed forensic reports on cases where children are either killed or seriously injured. And there was a swing to much more openness post-Baby P, where the anonymity was questioned, and the whole report was meant to be on the website of the relevant local authority. I think that the pendulum has swung a bit the other way now, and a bit more caution about making the whole thing available for the general public on the local authority website. I think probably it is a good idea for there to be as much openness as possible for people to understand why the decisions were made. I think social worker, there has been a real moral panic. I think there has been a feeling of very defensive practice in social work, because social workers are feeling quite victimized by a lack of understanding about why they make the decisions that they do and what were some of the pivotal points. I also think with the serious case review process, that since Monroe's report and the suggestion that we look at these more systemically rather than succumbing to the blame culture, that there has been a shift in how these things are reported and looking at it more from the point of view of what was happening on a number of fronts at the time, rather than trying to identify and blame individuals for not doing a good job. It is much more complicated than that. And I think if there's a way of getting that across to the public without compromising the anonymity of the child, we should be working to do that. But, you know, as all the speakers have said, that's a very difficult balance to strike. But to try and get away from blaming individual social workers for things that go seriously wrong, I think is something that we should be striving for.
We talk a lot about feedback for social workers and what is said about them. I wonder whether judges get enough feedback, please. I don't know, Louise, do you have any views to express about that? And if so, how do judges get feedback?
I'm trying to think of the conversations that I've had with judges and the cases that I've reported where I've needed to ask for permission. I don't think judges do get feedback from journalists particularly, at least not in a sense from me, because you don't feel able when you're addressing a judge in that capacity to say necessarily what you really feel or to argue your point. Certainly when I have stood up in court, and the only 2 times I've had to do that has actually been in front of you, it has been really frightening. It's quite
I'm delighted.
not because you are frightening, but
intentional.
because the forum is you are not in your natural environment. You are not necessarily sure of your ground. I was very fortunate 2 years ago to have Lucy Reed represent me in court in Newcastle on really quite a complicated case where I wanted permission to report something after the care proceedings had been finished. And my goodness was I glad to have her there, because I could not have got the result that was eventually achieved on my own. So if I could say what I really wanted to say to judges in a conversational way, in a discursive way, to be able to have those conversations and to weigh things up, then and to understand their reasons perhaps, which are not always delivered perhaps quite as comprehensively as you did in your most recent judgment, I think that would be very welcome. But, you know, how practical is it for judges to sit down and have chats with journalists? Probably not. We're very lucky to have, Judge Baker here tonight and yourself. But from the point of view of how the press feels about some decisions that are made, I don't think judges really get how frustrating it is.
Callum, I wonder whether you have a view as to whether in looking at transparency we focus too much on the performance of social workers and the function that they play, rather than other professionals, and for instance judges and the other professionals involved in the system, and how they perform.
I think there is scrutiny of judges is needed. One of the cases I covered was the case of Ben Butler, who murdered his daughter after a High Court judge had said that it was safe for her to return to his care. And my colleagues engaged counsel to argue in 2 different courts that the original judgment in the case, which the first judge had said that Ben Butler had in her view harmed his child, caused an injury to his child, would not have been made public had we not put that effort in to and spent that money on counsel to argue the case twice in court. So yes, I think is the very short way of putting
So
it.
transparency is a much bigger concept than
Oh,
simply
yes, it
looking
doesn't.
at it.
It certainly
On
doesn't just
social
apply
work.
to the statutory authorities. It certainly doesn't just apply to social workers or those kind of professionals. It should apply to the whole of the legal system.
Okay, thank you. Are there any points that to be made on in relation to that issue, please, that anyone would like to raise from the floor, please, from the audience? Yes,
I
sorry.
said I wasn't going to say anything, but I am. We wrote and spoke about the Ellie Butler case, and I've just got a slightly different perspective on it, which might be interesting and relates to that last question about serious case reviews. There was loads of information published ultimately about Ellie Butler's death. We now have, partly through the efforts of the press, all of the relevant family court decisions, both of Mrs. Justice Hogg and Lady Justice King. We have all those. They help us to build up a picture alongside the serious case review. In that particular case, much of the press attention was focused on perceived failings of Mrs. Justice Hogg, rightly or wrongly. In other cases, it will be focused on social work failings or perceived failings. It seemed to be focused mainly on the judge in this particular instance. But one of the things as the Transparency Project that we found really difficult to get to the bottom of was that complexity, that there are all sorts of mistakes and things that happen along the way that contribute to things going catastrophically wrong in cases. And although we had the family court judgments, what we didn't have, for example, were the independent social work reports, which had been so heavily relied on. And so I think in each individual case, there may have been good reasons why those weren't published, but if you're looking at the question of where does accountability lie for that awful case, you need to really be able to see everything. And we had the serious case review. We didn't have the individual management reports that feed into the serious case review. We didn't have the independent social work reports. So actually, it's an unfinished job if you really want to analyse where things have gone wrong in a public forum and discuss that. You're always going to be hampered by that lack of information.
We tried very hard to get the independent social workers report.
Okay, thank you. There's a lady here who'd like to ask a question. Thank you.
Thank you. Louise, I just wanted to start by saying that I think you've made some really good points tonight, so fair play to you. Also, in relation to what you've just been discussing, I think it's very much a postcode lottery. Long before you get to court, you rely so heavily upon different authorities. That can be social services, CAFCAS, the police. And no proper investigative work is done by these authorities. And therefore, when you get to court, you're set up for the fall.
Okay, so I think the point, if I may say, is would greater transparency create better uniformity of practice? Is that the point?
Absolutely, but it needs to be transparency and accountability across the board. Yeah. You cannot just say one person is responsible for the mess within the system. Accountability lays with the lower authorities as much as it does with the higher authorities. Okay. It's the power of the higher authorities that just secures and continues what victims are going through.
Okay, thank you. So, uniformity and transparency, is there a link? Please, would anyone like to... Sophie, would you like to deal with the point?
I think you do make a really valid point. I think there is a massive difference across the country in terms of thresholds sometimes in local authorities and also in terms of standards of practice, and that's something I have become more aware of as an independent social worker, so I do think that's a very fair point you make. I don't know whether in terms of using transparency in the court, whether that will rectify the situation. I think there is a much greater problem within the system, and it may not be about the family courts in this particular instance. My worry about that is if we're looking at using transparency to highlight concerns that have gone on in individual cases, I think there is very much still a culture of blaming, shaming, identifying social workers within that situation. And when that happens, it enables scant analysis about why situations have occurred, and it usually does lead to one individual social worker picking up the slack where actually the systemic failures aren't reflected on, and perhaps people up in the hierarchies of the organisation aren't using that opportunity to reflect and to change practice.
Is there a difficulty, though, in publishing good news? How do you publish good news, and who wants to read about it?
But I also think it's not for social workers or local authorities to decide what is good news as well. I think it's a very personal thing for families. And we may perceive a situation to be a very good outcome, but I think it should be for the families to choose if they want to or know the format to do that when they do that.
Callum, do you have a view on that in publishing good news?
I do. I will go back to what Lucy said about Mr. Justice Peter Jackson's recent judgment, which was delivered in the form of a letter to a child. My organisation published that as a story, and I think that was good news. It was a system of it was a story about a good outcome in a terribly difficult situation, but the system had worked as it should.
Thank you. Okay, we've had some written questions. Sorry, let's move on. We've got some more written questions, and Lucy will...
This is quite a long question, but probably needs to be read in full. This is from a representative of Mothers Unite UK. They say they're a group of 200 and rising, but almost all their members are too afraid to come to the meeting tonight in case they are accused of hostility, etc., etc. So they raise a question about injustices towards mothers and children who are victims of abuse within the family court system, and they call for more openness and accountability. What they say is, mothers who are victims of abuse are silenced by an impossible catch-22 situation. In the courtroom, there are shockingly ignorant and old-fashioned statements about abuse from court professionals, in particular judges, and accusations of alienation made without evidence. Mothers can't access justice or due process, and children suffer as a result. So the question that they ask is, why are so many mothers too afraid to speak out and attend these meetings? Is this justice, or is it covering up prejudice and old-school attitudes to women and children? They then say privacy shouldn't trump accountability. Many vulnerable children are going through family court, and they will talk amongst friends about problems anyway. The use of initials is possible. The press should have easier access and ability to report on cases.
Okay, does anyone have any views on that? Yes, okay, Louise, thank you.
That question seems to speak to the feeling that I often have, which is that I'm operating under a kind of super injunction that you can't say what you can't say, and everyone's very scared to say anything at all. No matter what certain judges have said about the right for people to complain, and that the idea of privacy is not to squash people's right to be able to have freedom of expression. What I hear from people who contact me very regularly after pieces are published is that they are very frightened. They're very frightened of speaking to me. There have been people who've invited me to come along to their court hearings, and whether or not I was going to go, in the end bottled it because they were too scared of what would happen if a judge saw a journalist turn up in court. And I think that sense of fear is the one that pervades this system to me as a journalist. I get a lot of people coming to me, not just in distress, but in a great deal of fear. And that does, I mean, obviously, these are not necessarily terrible injustices. There may not even be injustices at all, but there is clearly a very strong feeling that the family court system is abusing people who make use of it. Now, as a journalist, the only way that I can test that out is to expend the time and energy and money and persuade my editors to invest the kind of time that Callum has talked about and money on lawyers to be able to follow through those stories. And it becomes virtually impossible. But I do not get a sense of a system that people trust. And I think that is, given the efforts that are made by judges, lawyers and social workers to work well and ethically, that worries me enormously that this many people feel this bitterly about a system that is meant to help them.
Okay. Jonathan, I don't know if you have any views you'd like to express on that.
I think I'd rather listen to some more contributions before I respond to that. I mean, yes. Obviously I've got some views about things, but we're getting some quite interesting questions from various angles, and I'd like to hear a broader cross-section.
Is there anyone from the floor who would like, from the audience who would like to respond to the point that's just been made, please? Does anyone want to reply to that? No? Oh, yes, yes, there's a, okay.
I'd like to make a point about trust. About a year ago, I think it was Professor Lauren Devine at QC who made a point about disabled children. Now, my experience as a parent of a disabled child is that you are very closely scrutinised in a very frightening way, and then when something goes slightly wrong, like the school placement starts to fail, and we were in that situation, we were going through a tribunal to get, I mustn't disclose any more details, but the upshot was we were given a social worker who did not sympathise with us at all and reduced our package around our child on the basis that we were complaining about services. And it was a really distressing time for us. And after that, I realised that I couldn't ask for help in case I was deemed to be neglecting my child, basically.
So the point you're making is we as lawyers often talk about the balance between what's called Article 8 of the European Convention and Article 10. Article 10 is about the freedom of expression. It's not just about press freedom. And within the freedom of expression is the right to complain. And I think that's what you're touching on, the difficulty of expressing complaint about a system that operates in the way that the court system does. How do you, if you feel you've suffered a grave injustice, let's say your child's been taken away from you and you think it was wrong, how do you complain when there is this cover of confidentiality? Is that the point?
Well, luckily we didn't get to that point.
No, but in your particular case, I think that's the bigger point, isn't it?
We could have gone that.
Yeah. How important is that, please, that right to complain? Callum, I don't know if you have any.
Our right to report complaints and to report on perceived injustices, I think, is very important. It comes down to, and we would and we have argued, using Article 10 for that. Yeah.
But the argument tends to get focused very much on the freedom of the press. Actually, within Article 10, there's the other point, and that is it's a freedom of expression, and that includes the right of the individual to complain, does it not?
It does. Whether families who went to journalists complaining about the court system would be stymied by the privacy inherent in it is something else that we'd have to consider and that we might find difficult, I think.
Yes. Okay, fine, thank you. Madam, you'd like to raise a point?
Yes, my name's Maggie Civita, and I am a local authority whistleblower, so I think it's timely, on the freedom of speech aspect, I felt it was appropriate that maybe I commented. I'm a social worker. I'm now an independent social worker, having been dismissed from my local authority strategic management position for whistleblowing about children I was concerned about. Those children I believed were at risk of sexual exploitation, and there were children in care I also had concerns about, and I whistleblew about them too. I took my concerns to Ofsted. My comment is that I represent the dilemma between privacy versus accountability. I've had to forgo my privacy. My case has been reported in the press, and I believe that is right, because without that support, and I know journalists who have said that quite often it has been their intervention that has brought serious matters to the wider public attention. Versus accountability, I'm holding account those who I believe failed in their duties towards those vulnerable children. I respected that privacy, the privacy of my local authority in certain respects, to be able to put right the damage that it was doing.
Okay.
Until I realised that it was actually galvanising its resources to silence me rather than to take responsibility for what they were doing.
Okay, thank you. Can I just then put to Lucy, does lack of transparency discourage what is called whistleblowing, or unravelling of injustice, revealing of injustice?
I think that the person that made the point before was talking about trust and fear of what happens if you speak out. Her experience was an experience outside of court proceedings, but particularly within family court proceedings, which we're mainly talking about today. As Louise has explained, many parents are fearful of taking their case outside the family court arena and telling their story. Some who Louise has reported on will push that point and will say, I want to tell my story publicly, I want the world to know. But that's a really brave thing to do. And there are some for whom things have gone wrong and there have been failures either on the part of judges or lawyers or social workers, and they want to tell that story. And my view is that if that can be done in a way which doesn't compromise the welfare of the child or indeed the family members who are involved, then a person whose life has been affected, decided upon by the family court should be able to tell that story as long as they do it in a safe and appropriate way. There is a risk that those who are criticised will respond in a defensive way or will respond in a punitive way. And we all have to be very alert to that. And we have to be alert as well, as I think Hannah highlighted in the message that I read out, that what we shouldn't be doing is having a sort of knee-jerk reaction of every small failing being trumpeted on the front page of the Daily Mail or whichever newspaper, because there is a lot of bashing of social workers and professionals, and we should be focusing on the really bad mistakes, as well as trying to find ways to talk about those cases where things have gone right. It is difficult to write a good news story, there are less of them, but we do have to sort of constantly strive to redress the balance.
Okay, thank you. There's a lady at the back, please. You would like to ask a...
Yes, good evening. First of all, Louise, thank you for your great work. Lucy, thank you for all your work for the Transparency Project. If I could cover the question from the mother who said, why are all these mothers terrified to come? And the previous question about defensive social work. I've been working in the family courts as a volunteer for the last 9 years. Within my local county borough council, I cover more than one, but within my local one, there is a judge that is known for literally, even if parents are only on PLO and try to get advice, and then it goes to allocation. You've got Judge X. The lawyers, every single lawyer in town will look at those parents and say, that's it. Your children are gone forever. You will not get them back. This judge is notorious. I have taken cases with parents to the High Court in front of Lord Justices who have said, yes, we know about this judge. And this judge is so good at tying everybody up in legal knots that she cannot be, I apologize, this judge cannot be held accountable to anyone.
So can I ask what the point is that you're making, please?
The point is, we're asking about transparency in the press, we're asking about transparency about day-to-day social work, CAFCAS, independent social workers, but there is a level of judges who claim are not transparent, and they don't have to be. They don't have to publish their findings, they don't have to publish their reports, they don't have to explain themselves to anybody.
Okay, so thank you. Your point is accountability of judges. Thank you. I think if I may say, we've covered that. The gentleman over here, please. Thank you. Could we have the roving mic, please? Thank you for the gentleman there.
A completely different subject, you might be relieved to know. Could I ask the panel whether they have any good or bad experiences of the usefulness of academic research in this field? Because I can see that judges and other people might be worried about troublemaking journalists and not want to talk to those dreadful people. But you can have a cloak of respectability if you're an academic, and maybe that's a Trojan horse into this subject. any views on how useful academics have been? I'm not an academic, incidentally.
Nor am I. Thank you.
I think academics are fantastic, and I think it's imperative as social workers that we engage with academics, we keep up to date with current research, and we explore what new research is telling us to inform our practice, and I think that's incredibly important. And one example I would use is about attachment and the use of attachment within the family court. And there's quite a lot of discussion and research at the moment about the usefulness or overuse of attachment theory in terms of predicting future risks for children. And I've engaged in a lot of discussions with academics about that. I'm not sure I've come to a decision about it at the moment, but it's been really useful for me to start reflecting on what I've learnt at the beginning of my career, but also starting to challenge what I do think I know by having further discussions. So for me, it's incredibly important.
I'm just going to say, as it passes, it's not used enough, and when it's used, it's often used badly and inaccurately.
Thank you. Another task that I'm engaged in as an independent is training, and I offer a training course on evidence-based practice in social work. And I think the view is research is very important. It does give us a grounding on our knowledge base in social work practice, but one of the things that I urge caution about is to use research slavishly. And I think there's still a need to look at that individual family and not let the research drive the practice. I think we need to think about what the situation of that those individuals might be, and perhaps go against what the research is saying in order to better meet the needs of that particular family and their particular issues. So I think research is important, but I don't think we should be letting it determine all the time the kind of decisions that we make.
Okay, just briefly on this.
Yes, well, from this troublemaking journalist, I would say, yes, research is really interesting and useful. There's different qualities of research you come across, and you have to be quite careful of that. But in my reporting, I would say that there are 3 professors whose work has been really invaluable. One of whom is Karen Broadhurst, who has done work on repeat removals of children, in particularly babies. Professor Lauren Devine at UE, who has done very interesting work on risk assessment and how accurate that is. And Professor Paul Bywaters, whose work on poverty and the use of care orders is currently ongoing, but will continue to be really interesting.
Callum, you'd like to...
Very briefly, and I don't speak on anyone's behalf here, but it's interesting to note that under the practice direction that allows me, a registered, accredited journalist, into a family court hearing, an academic is not allowed at the moment.
Okay. Right. So, Professor Masson, you want to...
As a researcher, you can go to court if you have an approved research project. You have to have the research approved by the President of the Family Division, and for access to court documents, you have to go through the access panel of HMCTS. I've done it lots of times. And one of the things that, if we're talking about research can tell you is how different outcomes are in terms of the court orders made in different parts of the country, how different the length of cases are in different parts of the country, so that we actually don't have a justice system. We have lots of justice systems. Yeah. And my current work is looking at what happens to children after the orders have been made, because most of the research we have finishes with what the court said and not with what happens to the child afterwards. So, for example, what proportion of orders break down.
And you see, that's the area in which judges do not get feedback. Yeah. I would very much value knowing what happens to children after I've decided a case. Are there any other points, please, from the audience that anyone would like to raise? There's a gentleman here, and then
Hi. I want to make a point, really, more than a question to the panel. But I'll go back to what Louise is saying about doing research, really. I think what we're losing a little bit here, and what is really important, is coming back to the children and about what they think. And I think I was a social worker for 35 years with children in care, and I know that it is really difficult sometimes, apart from the bureaucratic barriers, is getting children to speak about their experiences. And I think part of that is about the stigma within our society about being in care itself, really. And I think that really needs to change. But
and would more transparency help with that stigma?
Yes, I think so, because I think the openness of the courts, the reason that children go into care, you know, and the reason they go through the court process, if that was more transparent, then society might have a better understanding of why it happens. I think there's a lot of myths around being in care, being adopted. I was in care myself. I was also adopted, so I've been through both systems. But the other thing that can happen, I think with Louise, maybe try to go and speak to care leavers. It's not the same, but not to reflect on what happened to them and what worked and what didn't work.
It's been done.
Right.
It's been done.
Okay.
Care leavers have a voice. Children in care don't.
But you don't get the main gist of...
Sorry, what I said was care leavers have a voice and they have organisations that they run, but children in care tend not to have a voice that's heard by the public.
Okay, thank you very much. I think the lady at the back, sorry.
Thank you. I was just trying to link the academic research workers with the feedback issue and whether that could lead into a greater transparency. But about 25 years ago, Bristol University research workers, or the academics, did set up a follow-up of selected cases that finished in court with a representative of each of the professionals. There was not a judge in it, but there were lawyers, there were social workers. I was there as a guardian, and we looked at the process and how that fell short or could be improved. I don't know what happened to it. I think it fell by the wayside because of lack of resource, time, etc. It's very time-consuming, but it was really interesting for all selected people in that particular process to get feedback and see what had happened, what could perhaps happen differently otherwise. I don't know if that's ever been taken up again, of those kind of forums.
Okay, well, maybe it should be. All right. Okay, thank you. Jonathan, would you...
At some point, I'd like to respond briefly to a number of the fascinating points that have been made.
Yes,
yeah, but do you want to do that now, or do you want to have some more fascinating points?
No, now. Please, thanks.
The first thing to say is that, I think, is that the basic system of justice in this country is open justice. All justice should be done in open, in public, unless there's a very good reason to the contrary. Obviously, we can think of certain security cases where there may have to be some compromise, but the basic principle is open justice. So this is an exception to the basic principle, and it's an exception that we have to be very rigorous in policing at all points and be prepared to justify and scrutinize and reconsider at events like this and at all points. And that is incumbent on all of us in the system, particularly the senior judges. Secondly, I want to say that I can't recall a case in which obviously, but High Court judges' decisions tend to get reported more frequently than others. I can't recall a case in which a decision of mine has been unfairly reported, or which I have had any cause to criticize any journalist who's reported on my case. Now, sometimes I'm slightly puzzled at what they pick up. The points that I think are interesting are not what they think are interesting, but it's not my job to write the story, it's their job to write the story. And in fact, in the High Court, we see more journalists than most courts do up and down the country. And as Callum and Louise will know, the print journalism industry is going through a crisis. Particularly local papers are under tremendous strain. The number of court reporters have been cut. And I dare say in most family courts up and down the country, they don't see a journalist from one end of the year to the next, whereas I see a journalist in my court most days, certainly several times a week. And there are journalists, and I try to work with the journalists, and particularly the Press Association journalist who frequents the family division, Brian Farmer, is someone who is only too ready to give advice and express thoughts and comments about, not so much about my decisions, but about issues about transparency and about reporting. The third thing point I want to say is this. The decisions we take as judges are incredibly important. The President said that since the abolition of the death penalty, there can be no more important decision that any judge can take than to take a child away from his or her parents and place that child in care or for adoption permanently. That is the most serious decision. And in my experience, judges take that responsibility very seriously. And I'm distressed to find that there are still judges who have a reputation of not taking it seriously and being risk-averse and always taking a certain course. I'd hoped that was no longer the case. But because it's such a serious thing that we do, we have to be able to justify it and we have to be held up to scrutiny. So where it goes wrong, it's right that the media should have the opportunity and the fair opportunity to scrutinize what we do and to criticize and to report on the criticism. At the same time, we don't want judges who are risk-averse. We don't want judges who always take the child away just in case they're concerned about what might happen if they get it wrong. You have to have judges who are prepared to take bold decisions if they think that's the way the evidence goes. So we've got to bear that in mind when we think about how we're going to deal with these issues. We've talked a lot about press journalism. We haven't talked much about social media. In my view, the greater problem now is not so much through responsible news reporting like Callum's or responsible specialist journalism like Louise's. The problem arises because of the Wild West of social media and comments that are made on social media. And that presents a whole new range of issues which we just haven't begun to talk about. As for research, I think what Judith says is absolutely right. Research is vital. I think we perhaps impose too many burdens on impediments to getting researchers into court. It's very important to know if judges, if there's the postcode lottery that you talk about in courts, if there are inconsistencies in the way in which we deal with cases. We need to know about that so we can address it in the way we train our judges. And there are many, many things I could go on about, but I think I'll shut up now. It's been I really enjoyed listening to it, so thank you.
Are there any other points from the audience, please, that anyone would like to make? We're going to finish at about 7:25. Madam, yes, thank you.
Hi. You mentioned about inconsistencies within cases. Now, if there's some secrecy around reporting, there's been a local authority that's been under heavy scrutiny recently. So if it's not reported about, how can we find out just how big this problem is? If other families can't see that there are similar issues going on with other cases as with their cases, how can they complain effectively?
Okay.
Well, that's the point of publishing judgments. Although there is the principle that the child is anonymous and the family is anonymous, the basic rule is the local authority shouldn't be anonymous. And I don't want to get involved in any cases, but obviously there are a number of cases recently whereby individual local authorities have been criticised in a series of judgments. So that's one of the consequences of reporting. But I don't want to focus... don't know what that was. We mustn't just talk about what goes wrong. So often we talk about what goes wrong. The vast majority of cases, the professionalism of social services and the other professionals is extremely high. I wish we could find a way somehow of focusing on that and the good stories and the good work that social workers and others do. We need to get a balance across the board.
Yes, okay, thank you. Other points, please, from the audience. Paul. He's now going to complain that I said that noise was his...
Certainly not. I wouldn't complain about you, Stephen. So my name's Paul Aprida. I'm the National Manager of FNF, Both Parents Matter Cymru, and a trustee of Families Need Fathers. I think I probably should have put my hand up earlier on, because the question I was going to ask is slightly existential, really, which is, what is the purpose of transparency? And I don't mean that in some kind of, let's have a dig at the concept. What I'm trying to get to is, what do we actually want it to achieve? And how will we know when we've achieved it or not?
Okay.
Because I think, if I may, lots of people will have their own personal experiences. And that informs the way that they view these things. But I think what I'd like to see is a much greater understanding of what's the purpose of this movement towards transparency. If it's just transparency for transparency's sake, I'm not sure people will be satisfied by it.
Okay.
Well, Mike, can I just say that what I just said a moment ago was suggesting we look at it from the other side of the telescope, which is we have a system of open justice. Why should it be kept secret? That's, I think, the way we should be looking at it. Not justifying transparency, but justifying the secrecy.
Okay. Thank you. No, there's one more question, please, and then I think...
Can I respond? Because
all right.
We're the Transparency Project, so I ought to have an answer to the question of what's the purpose of transparency. I take the point that Mr. Justice Baker makes. The question is, in one respect, the wrong way round. But the purpose of transparency is accountability, it's understanding, it's trust, and when you got those three things, you do better justice. That's the purpose of accountability.
Okay, thank you.
Yeah, I mean, the question around, hasn't been raised, is around the litigants in person. The family court setup being closed is very, very limited with the people involved. The judges locally see the same social workers, they see the same lawyers every single day. And the amount of litigants in person that are forced to come to family court now make it very, very difficult. And the amount of them who don't have any legal knowledge or limited capacity are affected because the transparency just isn't there for them.
So does the reduction in legal aid require greater transparency? Is there a requirement for greater transparency where there are restrictions on legal aid? Is there a connection between the two? Does anyone have any views? Thought Louise might.
Well, there are a number of journalists and some very effective campaigning lawyers who've spent the last, 3 or 4 years working incredibly hard to make it very clear how restrictive it is for somebody who's a litigant in person to get access to justice. For those two professions' parts, I think we have banged the drum as hard as we can to zero effect. I don't know if anybody else on the panel has more to say on that.
No? Okay, fine.
One of the advantages of transparency might be to demonstrate to the wider public and to politicians the importance of this work and the need for greater resources to be introduced not only to social work but also to legal aid. But that would obviously be, that's one of the purposes, one of the advantages of transparency. If we can show if we can show what we do is important and has such a fundamental impact on people's lives, and then perhaps at some point down the line, not obviously in the current climate, then there'll be a greater willingness amongst the powers that be to extend legal aid back to help people who at the moment are struggling, as I accept they are, as litigants in person.
Okay, thank you. Well, it's now 7:25, so I think we're going to end there. There are many, many, many points that could have been covered, and I'm sure that the debate could have gone on for a very long time. For instance, transparency. Is there a risk of it being misused in financial proceedings? Is an area that we haven't covered, or are there different issues that arise in those circumstances? But can I thank, first of all, our panellists, and perhaps we ought to show our appreciation. Thank you. But can I also express my thanks to you? The very holding of this debate is surely a signal of the transparency that we are trying to create. For a system to operate properly, a system of justice, it's got to be understood. People have to feel that they are involved in the public institution that we are under debate. The family court serves the community. That's its purpose. It's not the other way around. And to serve the community means that we must explain ourselves adequately to the community. One of the things that we, and I stress that, we have tried to do here is to allow people a greater understanding or insight into the work that we do. It doesn't just come from the press. It comes from a number of other initiatives that we've got in place, and if people would wish to support them, please do. Can I mention conferences to which the public are invited? They are all advertised on the Family Court Info website. We'll be holding some more now that we're back at the Civil Justice Centre. Theatre performances, interactive theatre performances with a theatre group that I've set up with others at St Brendan's College. The next performance will be the 11th of January. We put action from family law scenes on the stage. We stop the action. The actors remain in role. The audience talk to the actors in role. So 6 o'clock, 11th of January, St Brendan's Theatre, and it will be advertised again on the website once the notice goes out in the next few days. Participating in this sort of debate, it's terribly important that we do that so that we are able to listen to you. And I can assure you that I certainly learn a great deal about what I should be doing by attending these. We have family law classes where we try and help people understand what happens in the family court. They're run by Stephanie Cope, District Judge Stephanie Cope, and also the pro bono, the free legal advice that is available on alternate Thursdays. Those are examples of how we are trying to help people to understand the work that we do. And if you feel able to join in on them, please do. But thank you very much indeed for attending.
Right, don't go anywhere yet. I feel, for somebody who wasn't supposed to be on the panel, you've heard rather too much of my voice tonight already, but I do need to tell you why you're here, apart from to hear this very interesting debate. You should all have a copy of this on your seat. Although it's published in July 2017, this is effectively our slightly belated launch event for our guidance note on the publication of family judgments. So you all have a copy of it there. It's available for those of you who find the text a little bit tiny on the website to download in a different format. I just need to tell you a little bit about that, please. We're here with the assistance through a grant of the Legal Education Foundation, which has made the preparation and publication of the booklet possible and has made this event possible. We've put this document together collaboratively as part of a team. It's one of a suite of guidance notes we've issued, which is not meant particularly for lawyers. It's meant for the real people who are dealing with these cases and whose lives are being decided on. It's meant to be a tool. If you're a social worker, if you're a lawyer, talk to your clients and your service users about making good decisions about whether or not, in their case, it's right for their judgment to be published, and if so, how you might go about doing that in a way which is safe and responsible for everybody involved. That's what it's meant to be about. It's meant to be a tool so you can have discussions, lawyer to parent, social worker to parent, guardian to their own lawyer in giving instructions on behalf of a child. It's meant to help you think through the pros and cons, the pitfalls, the question of whether this is a judgment that cannot be published in any way, or it could be published if it's done properly and carefully with appropriate anonymisation, thinking about jigsaw identification, etc., etc. It doesn't seek to give any answers. It just gives you some points to think about early on, so people are not bounced at the end of a hearing and make bad decisions about whether a judgment should or shouldn't be published. It might lead one party to make a positive application for publication. It might lead another to oppose publication. We're not suggesting there's a right answer in any particular case, but hopefully it will be helpful, and hopefully the other guidance notes that we have published will be helpful. So we're going to finish now. I hope as many of you as possible can stay to have a drink. There are some free drinks provided by Simpson Miller. Thank you very much, lovely Simpson Miller, who have sponsored that part of our event tonight. So please have a drink. There is a cash bar if that is inadequate for you. We have to be out by 9 o'clock. I think some of our panel members, if they can, will stay and carry on the discussion. One or two have to rush off and catch a train. But please do stay and carry on the discussion. I don't feel like we've finished it. Talking is good. Thank you.